Hello, everybody, and welcome to the webinar. This is Abby Bauman from EPAY Systems, and I just want to thank you all for attending our webinar today, State Biometric Privacy Laws, Best Practices for Compliance. Today, we are thrilled to have with us Tom Allring, an associate at Seyfarth Shaw and a member of the firm's Labor and Employment Department. Mr. Allring represents some of the world's largest corporations in litigation with millions of dollars at stake in a broad range of employment disputes, including defending employers throughout the U.S. in complex employment discrimination class actions, wage and hour class and collective actions, and single plaintiff actions for wrongful termination and discrimination. Mr. Allring was recently recognized as a 2016 Illinois Super Lawyers Rising Star in the area of class actions, an honor awarded to only 2.5% of attorneys under the age of 40 in the state. Welcome, Tom.
Thanks, Abby. I really appreciate it. Thank you for the warm welcome, and thanks for everybody for tuning in today. It shouldn't be too long of a presentation. I'm here to just kind of give an overview of the biometric privacy laws specific to Illinois today. First, I just kind of want to get the legal disclaimer out of the way. The purpose today is purely educational. You shouldn't construe anything in this presentation as legal advice, and I would highly recommend, if you have any specific questions, seeking your own counsel to make sure that you're in compliance with the law as overviewed here today. And I should also clarify that today's presentation is going to be limited to the law and not specific questions regarding EPAY systems. To the extent that you have questions about EPAY systems, I would encourage you to reach out to them directly.
Thanks, Tom.
Thank
now,
you. Go ahead.
If I'm just quickly back on the other slide. I know we have a lot of clients on the line, but those of you who aren't necessarily familiar with EPAY, here's a quick overview. EPAY Systems delivers integrated human capital management technology that helps with everything from recruiting and paying employees to retiring employees. We have a strong legacy in workforce management, and our time and labor management technology is at the core of our human capital management system. You'll see on the slide all the areas that we can help with, from applicant tracking to payroll, benefits administration to performance management. Next slide. And I just want to let you all know that today's webinar is a part of EPAY's compliance webinar series. Here at EPAY, we are happy to offer our clients and prospects access to quarterly compliance webinars in partnership with Seyfarth Shaw. We believe this education is really important to you and our clients, so we really want to be your partner in compliance. On the screen, you'll see a recap of what we've covered so far this year. All of these recordings can be found on our website and our YouTube channel. And be sure to watch for the 2018 compliance webinar schedule in your quarterly newsletters or on our website. With that, I would like to get started today. If you have questions during the webinar, please type in the question box. We will try and answer as many questions as possible at the end of the presentation. So Tom, I'm turning it over to you.
Awesome. Thanks again, Abby. I really appreciate it. Today, just kind of a general overview of what I'll be talking about. First, I'm just going to give a general kind of landscape, high in the sky overview of what biometrics are, the landscape today out there. I know it's a hot issue and it impacts a lot of companies and employers. Then I'm also going to get into talking specifically about the Illinois Biometric Privacy Act. I know a lot of you guys are in Illinois, so this is the one that everyone is talking about. Specifically because it's typically considered the most stringent law or biometric law in the country. There's a few different laws, but this one's obviously of utmost importance to companies and employers in Illinois. So along the same lines, I'm going to talk about what the law requires, and then also provide some general best practices that companies can follow or employers can follow for utilizing and maintaining biometric timekeeping tools to make sure that you're in compliance with the law. So the first question we're going to talk about is, what is biometric data and technology? I'm sure you're all familiar with the technology since you're on the webinar, but biometrics as defined in the Illinois statute include a variety of things. The primary characteristic that they all have is that they're all used to identify people, right? So, this includes fingerprints, voice prints, eye scans, and the one distinguishing feature about these things is that they're all unique to an individual, right? So unlike a social security number that can be changed, you can't change your fingerprint. And along those same lines, like we'll talk about in a bit, that's one of the reasons like these laws exist is because, it's very important to an individual and can't be changed. So there's biometric data laws currently on the books in a couple other states, and those are Washington and Texas, and in addition to Illinois. And then there's other states also, including Alaska, Massachusetts, Montana, and New Hampshire that have introduced legislation with varying levels of success, meaning some are, languishing in the House, some have been rejected or modified, and so forth. But it's important to know that not only, especially companies out there that are listening that use this technology in other states, it's important to know and keep an eye on and keep up to date with the legislation in those other states to make sure that you're compliant with those specific requirements as well. I should also note that even in states where there are no laws yet, or there are no laws in place, you should still exercise caution when collecting and storing biometric data. Just because there's not a statute specific to the collection and storage of biometrics doesn't mean that other statutes or other claims could arise out of the handling of that information, like negligence claims, data breach claims, etc. So it's important to understand at the outset that this isn't just an Illinois issue, it's also applicable in other states as well. So typically the states, like I mentioned before, that have the actual specific laws about biometrics are Illinois, Texas, and Washington. If you look at the legislative history of a lot of these statutes, the reason that they've been enacted is mainly due to a concern about, like I said before, about the uniqueness of the identifiers, and the concern is that if somebody provides it to a company and they don't really know what's done with it afterwards, there could be a heightened risk if it's not protected in the right ways, that it could be leaked or hacked or so forth, and disclosed to people that could take advantage of that. And once they have that information, then there's really no going back because it's a unique characteristic. The Illinois Act was passed in 2008. So it's new in the sense that it's kind of hot and people are talking about it, but not new in the sense that it's just a brand new law. It's actually been on the books for a while. And Texas enacted their law in 2009, and Washington is the most recent to pass their law in 2017. One thing I should note about all of these laws in all three states, Illinois, Texas, and Washington, is that they're really still developing, right? So while we have the plain language of the statute and we have an understanding of what that means, from a legal perspective, a lot of the language in the statute hasn't really been tested. There hasn't been a lot of interpretation. So it's important to understand that this is just kind of the initial wave of interpretation of this law. So it's important to keep up on it and keep up with developments in the area in the years to come, especially in other states. And like I said, to keep an eye on other states that might be contemplating passing similar legislation. So the Illinois Biometric Privacy Act, if you look at the legislative history, it was actually created in response to the bankruptcy of a company here in Illinois called Pay by Touch. And the purpose of the company was to pay using your biometric information, and it was something that companies can use and essentially act as a vendor. Well, Pay by Touch went bankrupt, and they had a lot of biometric information already that they had collected from consumers. And the concern was raised in the legislature Well, now that they're in bankruptcy, what's going to happen with consumers' biometric information? They don't know what's going to happen. Is it going to be sold to a new company? Is it going to be expunged or terminated? No one really knew. So the law is very clear that it was derived or was created as a result of this specific bankruptcy in the consumer context. That doesn't necessarily mean that it doesn't apply in other contexts as well. Employers, I think, also are subject to the law, but the initial thought behind it was to protect consumers, not necessarily employees, but it applies to both. This is the direct quote from the statute. It specifically regulates the collection, use, safeguarding, handling, storage, retention, and destruction of biometric identifiers and information. So while that sounds kind of broad, it's really quite straightforward. It regulates every aspect of a company's use of this information. And like I said, it's still a relatively new statute, and courts are still just starting to interpret it. Okay, so how are biometric identifiers and biometric information defined in the statute? So the statute defines biometric identifier as a retina or iris scan, fingerprint, voice print, or scan of hand or face geometry. And it also specifically excludes a few different things: writing samples, written signatures, photographs, human biological samples, demographic data, tattoo descriptions, and physical descriptions. So this is one of the interesting parts about the statute, is that it not only regulates biometric identifiers, but also biometric information, which is defined as any information, regardless of how it is captured, converted, stored, or shared, based on an individual's biometric identifier used to identify an individual. So this biometric information definition is much broader than identifier. So it arguably acts as a catch-all. And like I said before, even though it hasn't really been defined or interpreted by the courts, a plain reading of the statute suggests that biometric information is really an encompassing and broad definition to make sure that the statute captures as much information as possible. So all three laws place restrictions on the collection and storage of biometric identifiers. That's what we talked about before, like the actual eye scans, the actual fingerprints, the actual voice prints. Illinois and Washington have a broader biometric information definition, which covers more information. So that's information that's based on an identifier, like a fingerprint or a voice print, et cetera. Specifically, Washington restricts the enrollment of biometric identifiers, which is defined as capturing a biometric identifier or converting it into a reference template. So Washington arguably goes even a step further and says specifically, even if you're not capturing an actual fingerprint or an actual facial scan, if you're converting it, that would arguably still apply as well under the Washington statute. Texas, by contrast, is narrower. It only protects the actual biometric identifiers and does not contain that broader provision. And here's another slide that again includes that broader definition that we just talked about, biometric information. That's important to note because you're not just subject to the statute if you're only collecting an actual fingerprint, but arguably if you're collecting something that's based on that fingerprint. So the specific requirements of the Act, and this is probably the most important part of the presentation. There's really four primary requirements in the statute, and this is the Illinois statute, I should clarify. So you need to obtain notice and consent before you obtain a fingerprint or biometric information. And employers and companies that are collecting or using biometric technology need to have a written policy on file, and it needs to be publicly available, telling telling the employees or consumers or whoever it might be, whoever's biometric information is being collected, what the policies are, how you're safeguarding it, and how long you're going to keep it before you get rid of it. Also, the laws all contain a prohibition on disclosure to third parties. This one's obviously, because you want the purpose of the law is to make sure that, if you're giving your information to whether it be your employer or another company, that that they're not just going to willy-nilly turn around to another company and sell your information, use it for marketing purposes, etc., without first obtaining your consent. And then also, finally, standard of care. That just means that biometric information needs to be kept in the same manner that other sensitive confidential information is kept by the company or employer. So, for example, if you have a policy, where you have a bit stricter compliance requirements internally for safekeeping of people's social security numbers, their account numbers, so forth, anything that you would typically consider confidential, that biometric information needs to be kept in the same manner as all the other data that employers and companies collect. So first, this is probably the most important requirement of the statute, at least of the Illinois statute. So all three laws require notice and consent before obtaining biometric information. The Illinois statute specifically requires an employer or a company to obtain a written release. And in the employment context, the statute says that means it must be executed by an employee as a condition of employment. So it's important that you have either a form in place and/or through the technology, you're capturing somebody's electronic signature and telling them what's being collected, when and how long you're keeping it for, and getting their sign off on that to make sure that they understand what's going on. It's all about transparency with this requirement. Texas and Washington, on the other hand, do not specify that consent must be given in writing. So that's kind of a big difference between Texas and Washington and Illinois. So in Texas and Washington, arguably, if you had some sort of oral consent, or you have a orientation and you tell them about it, and you say, hey, is everybody okay with providing your information? Arguably, under those statutes, that would be enough. Obviously, I think as a matter of best practices, no matter where you are, whether it be Illinois, Texas, or Washington, it would be best to obtain some sort of written record of consent rather than just relying on a purely oral representation by an employee or a customer. One more notable Washington exception is that the notice and consent provisions do not apply to data collected for security purposes. So that means stored for the purposes of preventing shoplifting, fraud, or any other misappropriation or theft of a thing of value. It seems to be that was probably a carve out that was lobbied for by certain companies to say, hey, we need this for security purposes. So that's kind of a big exception to the Washington law that doesn't exist in the Illinois and Texas laws. Okay, retention is the other big piece of these statutes. And the Illinois Act specifically, like I said before, requires a written, publicly available policy with a retention schedule and guidelines for permanently destroying the data. Okay, so what does that mean? Specifically, and it's kind of unclear, but it specifically says in the statute that data must be destroyed when the purpose for obtaining such data has been satisfied, or within 3 years of the individual's last interaction with the employer, whichever occurs first. So this is one of those ones that, again, I wanted to circle back and make clear is it has not been interpreted yet. So what does when the purpose has been satisfied mean? We don't really know yet. and courts haven't weighed in on that, and the statute doesn't really tell us. So all we can really do is guess. But I think at this point, it would be safe to at least have a policy that tries to be compliant with that. And by that I mean, removing an employee's biometric data after someone is terminated, and at the very latest, a few years after their last interaction with the company, and sticking to that and making that a protocol that you have in place internally. The policy under Illinois law must be made available to the public, or as it puts in the statute, it quotes publicly available. Again, that's not a defined term in the statute, so we don't really know what that means, because courts haven't weighed in and said, well, here's what we think publicly available means. It's a safe assumption, though, to speculate probably that it means, at least being available to your employees who are subject to the timekeeping or have consented to it. So, they can go and reference it if need be. Like I said, again, it's all about transparency and making sure that your employees or your customers can go somewhere and be like, well, I just want peace of mind to know exactly what they're doing with my fingerprint or my mathematical representation, my fingerprint. Whether or not that means it must be made public on a company's website, that's yet to be seen. But for now, I think it would be a good practice to, at the very least, have the policy posted on, if you have like an internal employee website or some sort of portal, making it readily accessible for, at the very least, your employees. Texas differs a little bit in that it requires only that employers destroy biometric data within a reasonable time, but not later than 1 year after the biometric data is no longer needed. Again, what does no later than 1 year after the biometric data is no longer needed mean? We don't know, because courts have not interpreted that provision. So if you're in Texas and you're using this technology, I think the safe bet and the safe best practice would be to make sure that everything's being discarded at least 1 year before the relationship with the employer, the customer, is ended. Again, in Texas, kind of like Washington, if data was collected for security purposes, the purpose for collecting the data is presumed to expire on termination of the employment relationship. So that's a little bit different, and they actually spell out what that means in the security context, whereas in the other context, it's more open-ended in the Texas statute. Washington requires employers to retain biometric data no longer than is reasonably necessary. Again, this provision in Washington has not been interpreted by courts. It's not defined in the statute, so we don't really know what that means. But I think that and we'll talk about this a bit later, but for best practices, it would make sense to, try to comply if you're in multiple states with the strictest law. For retention, that would be Texas, but for a lot of the other statutes, it's the Illinois statute. Okay, another big one, prohibition on disclosure to third parties. And we talked about this a bit earlier. So obviously, I think one of the key points of the statute is to make sure that employees and customers know and have the security of knowing that their information, their biometric information, is not being willy-nilly provided to anybody without their knowledge or consent. The Illinois law provides a few exceptions, and I've listed them here on this slide. You can disclose biometric information, obviously, if you obtain consent from that individual. What consent means, whether it be written or not, we don't know, but you have to at least have some sort of consent from the employee before you disclose it to someone else. That would probably be different than the consent that we talked about earlier, where you're obtaining it saying, hey, we're collecting your information, and you acknowledge that and accept that. This is a different form of consent. there's also an exception if the disclosure completes a financial transaction that's requested by the individual. And then the third exception is that if it's required by law. And the third and the fourth exceptions kind of run together, and presumably by law, the statute means that if it's required by a warrant or subpoena. So if somebody if the FBI comes to your office and says we need, John Doe's biometric information, the statute provides an exception to provide that to them without violating the statute. And then the last major requirement of the laws is that all three laws require that employers exercise reasonable care to protect biometric data. And again, the reasonable care standard is kind of it's a moving target, and probably depends on your jurisdiction. So like I said, it's important to consult with your local attorneys to make sure that the reasonable standard of care is in fact in place to the extent you're collecting and storing data. The Illinois statute defines standard of care as the reasonable standard of care within the industry and in a manner that is the same as or more protective than the manner in which the business stores, transmits, and protects other confidential and sensitive information. And it lists a few specific examples, and I touched on a few of them earlier, but social security numbers, account numbers, passwords, driver's license numbers, whatever you're doing to protect those sorts of things, you got to be doing at least the same level of care for biometrics. And again, whether or not you're compliant regarding capturing and storing and collecting these specific things listed here is something that you should ensure and will probably vary based on your jurisdiction. Texas requires reasonable care in the same way the company treats other confidential info. Again, that's pretty much the same standard as in Illinois. Again, it's a little bit vague and not defined, but you can take steps, through your internal counsel to make sure that the way you're treating that information is up to snuff in your state. And Washington requires reasonable care to guard against unauthorized access to and acquisition of biometric data. Pretty much the same standard as Texas and Illinois. Okay, so all three statutes provide a cause of action, and all three provide civil penalties for violations of the statute. The Illinois statute, as I'm sure all of you have probably read in the news, is the only one that actually provides a private cause of action to an individual whose biometric information was captured or collected, and provides civil penalties for those violations. In Texas and Washington, it's different in that only the state attorney general may bring suit to enforce the laws. To date, I personally am not aware of any actions that have been initiated by Texas and Washington to enforce their biometric laws. That's not to say that it won't happen. I'm sure they have it on the books for a reason. It just, you hear more about the lawsuits in Illinois because, plaintiffs' lawyers have caught on to the statute and are bringing cases under it because it provides that private right of action that the other two states do not. Okay, what are the penalties under the Illinois Biometric Act? So it authorizes $1,000 or actual damages, whichever is greater, for negligent violation of the act. Again, like I've said, this is a common theme throughout the presentation, but what this actually means is still in flux. So actual damages would presumably be, like somebody's identity is stolen. So if someone's identity is stolen, you can show that it was a stolen, and someone bought a car on using my information, and it was $50,000. Pursuant to the plain language of the statute, you'd probably be entitled to $50,000 instead of $1,000. And again, a violation has not been defined yet either, because like we talked about, the statute requires a few different things. Obviously, plaintiffs' lawyers to date have argued that every violation entitles a plaintiff to a separate damages award. This is something, again, that has not been interpreted or decided. Obviously, there will be litigation over that, and I'm sure that courts either in Illinois or elsewhere will have some opportunity to either limit or define what exactly a violation means in the context of the BIPA, and specifically in the context of how much of an award is allowable for each violation. So $1,000 for negligent violations. What is negligent? We don't really know. Again, it's kind of a moving target. And then $5,000 or actual damages, whichever is greater, for intentional or reckless violations. What's intentional or reckless? It's still to be seen. My gut is that plaintiffs will argue that a reckless violation or intentional violation is having knowledge of this law, saying, you know what, screw it, we don't feel like we need to abide by that law, and something happens where a plaintiff or an employee or a customer suffers some sort of harm, and a court could maybe find that because the employer was reckless in failing to comply with the law, that the plaintiff is entitled to this higher $5,000 violation award as opposed to the $1,000 violation award. And then in addition to those statutory penalties, the statute authorizes injunctive relief and attorney's fees and costs. What I mean by injunctive relief is that the court could say, listen, employer, we find that you've violated the Biometric Privacy Act by not obtaining consent and using biometric technology. I order you to either stop using the technology or become compliant with the law. And then attorney's fees is self-explanatory. If you are found to be in violation of the law, the plaintiffs can also obtain reimbursement for their attorney's fees and the costs that come along with bringing that action and prevailing in that action. Like I said, again, Texas and Washington are different in that only the state attorney general can bring suit to enforce those laws. While they have civil penalties, if you were found to be in violation of those laws, those penalties would not be going to your employee who sued you; they'd be going to the state. And again, those I'm not aware of any penalties in those states yet. Not to say that there won't be some actions brought in those states as well. Okay, so that brings us now to best practices for compliance, and it's pretty straightforward. They flow directly from the four main requirements in the statute. First, make sure that you provide notice and obtain written consent before storing or collecting biometric data. And really, I think that, to me, the crux of the statute is consent, making sure that people are aware of what's going on. You can't say that your privacy was invaded if this is something that you, as an employer or a company, have proof that somebody said, I'm okay with this. And in a lot of ways, that kind of cures a lot of the concerns that the statute was enacted to address. Take steps internally, if you do not already, to ensure that biometric data is not sold or disclosed to third parties, whether that be implementing your own internal protocol or updating it. Also making sure that any vendor you use takes these steps to make sure that it's the data is in safekeeping. The second bullet point is the same thing, is to make sure that you're not exceeding the scope of the consent obtained. So what I mean by that is, if you, in the consent form, you say you're providing your consent for us to use your biometric information for timekeeping, don't go and use it for something else. I don't know what that would be, but if you use biometric information at your company in a way other than timekeeping, make sure that you're getting consent to use it for every purpose internally, not just one purpose, to prevent an employee or someone turning around and saying, listen, I gave you my consent just to keep track of my time, not to do XYZ. The third bullet is to make sure you have a written policy and make it publicly available. We talked about this earlier, and I think in the white paper that was distributed, there's a sample policy that you can tailor for your own use if you like. And again, to make sure you're consulting with your attorney and make sure that the policy is consistent with your internal practices. Publicly available, we talked about that earlier. I think at the very least it should be somewhere where the employees can find it, whether that be on a internal portal or an employee website, but finding some way to make sure that the employees can access it. We talked about this already, but implement security protocols for the protection of the biometric data. So if you're using a timekeeping system and you're the entity that is actually the one that's housing the data in any way, whether that be at your facility, whether that be in the cloud, however it might be, to make sure that you have protocols in place to protect that info. Again, to reiterate, you should be protecting the data in the same manner you do with other sensitive information, social security numbers, driver's license numbers, etc. And this is something that we haven't talked about yet, but the protocols and the policy, if you have a general privacy policy already, you could fold the requirements of the privacy policy into your global or your more general privacy policy. Again, you should consult your attorney to make sure that you're doing that the correct way. But the key is that there's an actual policy and it hits on the points that are in the Illinois statute and that it's publicly available. How you go about that, it could differ. But just making sure it exists is the main point. And again, make sure you're being reasonable and using a standard of care that is applicable in your jurisdiction to maintaining and collecting sensitive information. Some other best practices. I don't know to what extent everyone is familiar with state data breach laws. But this biometric information arguably is covered by a lot of those state laws. So in the event that there is a breach, make sure that you're taking every step necessary by local state law to notify people. And again, I think the best place to be would probably to consult a data breach attorney or your local counsel to make sure that you're taking the right steps depending on your jurisdiction. These laws kind of vary, so it's important to know the differences according to states. And I think that this is also, this is applicable in not just the states with the biometric laws. It's applicable in every state. So if you're using biometric timekeeping in a state other than Illinois, Washington, or Texas, and there's a breach, make sure that you are using the procedures that are applicable in that state. Let's see. Looks like we touched on all these other points already in previous slides. This one's important. So biometric data is considered personal information under a number of state data laws, including Illinois, Iowa, Nebraska, New Mexico, North Carolina, Wisconsin, and Wyoming. I know that's kind of a long list and probably one that's tough to memorize, but you can keep these slides in case there's ever a biometric breach in any of those states, and then you'll know automatically that you need to take action to notify people in accordance with the data breach notification laws. Okay, that's all I have today. I'm happy to answer a few questions if anybody has any. I will take a look through the slide here. Okay, the first question is, do hand scans count as biometric technology? So hand scans specifically is not included in the definition, at least in Illinois, as a biometric identifier. I guess it would depend on if a fingerprint is involved, because if a fingerprint is involved, arguably it would apply because fingerprints is specifically listed in the definition of biometric identifier. That's a good question, though. I couldn't say for sure because there's no answer really, other than what we know exactly in the statute, because nobody's sought to bring a case based on a scan of a hand scan as opposed to a fingerprint or a facial scan. But if it does, my gut is if it would include the fingers, then it would probably be covered by biometric identifier definition. Okay, next question, a good question. Does a written release include electronic signatures with an online benefit system? I guess it would depend on what this question means by online benefit system. Illinois does, and this is specific to Illinois, and again, you should consult your lawyers if you're in another state, but Illinois does have an Electronic Signature Act, which makes electronic signatures, essentially as valid as any other form of written consent. So at least in Illinois, we think that an electronic signature would suffice for consent purposes. And again, I apologize, but because I don't know what you mean by online benefit system, I think that if what you mean by that question is that if the consent is included in some sort of other system, I think that would be fine, but you'd have to be careful to make sure that the employee or the consumer really sees it. It's clear and conspicuous, meaning it's not buried in the bottom of some other text or in the footnote or so forth. If you do it like that, you run the risk of an employee or someone making an argument. Well, that's not binding. My consent's not binding because I didn't see that. I didn't understand it. You want to present the notice and obtain consent in a way that's very clear and very conspicuous to make sure that it's not subject to challenge at a later date. Here's another question. Is a time and attendance system considered a third party under the BIPA? Again, without knowing exactly what you mean by a time and attendance system, unless it's being used by and controlled by a different entity other than yourself or your company, I would not think it would be a third party. It all depends on who's controlling it and who has access to it. If it is a different company and the other company can access the biometric data, I think that you would want to make sure that when you obtain consent, that the employees know that the time provider that might be different than the technology provider also have access to it, to make sure that they understand that and that you're getting their consent for third-party disclosure. Here's another question. Does a time clock that takes a picture of an employee, it does not do facial recognition, classify as biometric? The pictures are stored for 1 month. So that's an interesting question, and it would really depend on the particulars of the actual technology. Photographs are specifically excluded from the definition of biometric identifiers, but facial scans are recognized. So it would depend on if the photograph is being converted into a facial scan, then arguably the act would still apply. But if it's not, if it's just a pure photograph, that would clearly be excluded under the statute. But again, an analysis of that would really depend on, obtaining more information about what the technology actually does, whether or not that photograph is just a photograph or if it's converted into something more. It would depend on if it's converted into a facial scan, which is then used to identify somebody, then arguably the statute would apply. But like I said, if it's just a photograph for the sake of a photograph, then it would probably be excluded. Here's another question. If the employees are from a staffing company and not our employees, does this apply, meaning the laws? That's a good question. So it depends on if you are the one that's implementing the timekeeping system. So if, and we've seen it in different situations, but we represent a lot of staffing companies, and sometimes they implement their own timekeeping system, their own time clocks at the facility. If that's the case and it's completely separate, then the statute, I don't think, would apply to you unless you're doing it for your own employees also. But yeah, it really depends on who has control. The act really applies to private entities that are collecting, capturing, storing the information. And if a staffing company is doing that for their own employees on your premises, but you're not specifically doing any of that, I don't think that the statute would apply. You probably want to make sure, though, that your contract with the staffing company is explicit that the timekeeping system is their responsibility, to make sure that there's no confusion as to whether or not the technology is something that you're implementing. Here's another question. What if we use a different platform for payroll and EPAY for time attendance? Will the payroll platform be considered a third party? And this goes back to the question I answered earlier about the time and attendance, whether that's a third party. It really depends on whether or not the time and attendance entity has access to the information, whether or not they're involved. If it's completely separate and you're not sharing the scans or any biometric information itself with that third party, I think that then you wouldn't have to take any steps on that. You would just be able to just make sure that they're walled off from that, and I don't think you necessarily have to obtain employees' consent because you're not sharing it. You're not sharing their actual biometric information with the separate timekeeping vendor. Okay, thank you, everyone. I really appreciate it. Thanks for tuning in today. If you have any follow-up questions, you can reach out to EPAY or to myself, either way. Thank you again, and everyone have a great day.
Yeah, everyone, we will be sending you a copy of today's slides as well as our white paper that we've created for this. So thanks again, and sorry we couldn't answer everyone's question. We will try and reach out to everybody after the webinar. Thanks, and have a great day.